That'll take my first minute. Thank you, Chair. On behalf of my colleague, Mr. McDonald, let me start by thanking the committee for this opportunity to present on Bill C-45. We represent FETCO. That does stand for Federally Regulated Employers, Transportation and Communications. You now probably understand why we say FETCO. We've existed as an association for over 30 years. Our members employ about 500,000 workers, or nearly 2/3 of all the workers in the federal private sector. FETCO members are household name organizations. A list of our members can be found in the appendix of the material that I've provided you with today. It is important, though, that I paint a picture of the work our members do to get a full understanding of the safety risk of which we will speak today. FETCO members employ the following: air traffic controllers, crane operators, heavy equipment operators, pilots, train conductors, train engineers, and truck drivers, to name just a few. While we are here today specifically to represent FETCO, it's important to note that FETCO has been collaborating on the issue of the legalization of marijuana for the past 2 years with a wide range of employers and employer associations, both federally and provincially regulated. We were all active participants in the task force on the legalization and regulation of marijuana. The tie that binds all of these organizations together, they all engage in safety-sensitive work, where workplace and public safety concerns are paramount. We provided 2 documents to assist in your committee's deliberations. We're happy to refer to those in the Q&A. Our key message is this: with the introduction of Bill C-45, the Government of Canada has failed to address the impact of recreational marijuana on the workplace. This is a serious oversight with potentially catastrophic consequences for workers, employers, and the public at large. There's already a safety gap in Canada as it relates to the presence of alcohol and drugs in the workplace. The legalization of cannabis is only going to make this problem worse. Evidence from U.S. states that have already legalized cannabis, such as Colorado, reveals startling trends, and you can see some of this in the material we provided with you. This data shows that consumption is going to increase substantially when legalization occurs. This matters to employers, as we know the same increase in use is going to find its way into safety-sensitive workplaces. Employers have no moral judgment on the legalization of cannabis. Our concerns are exclusively rooted in safety. We therefore ask the following: that your committee amend Bill C-45 in such a way to introduce a mandatory alcohol and drug testing framework in safety-sensitive federal workplaces that focuses on the full complement of testing approaches: pre-employment, reasonable cause, post-incident, return to work, and random. A legislated fitness for duty framework will accomplish several objectives. First, it will serve as a deterrent for individuals contemplating being at work under the influence of alcohol or drugs, thereby reducing the risk of workplace accidents. Simply put, random alcohol and drug testing works. It is a preventive measure that changes behavior and, by extension, improves safety. Second, it will bring Canada in line with many other jurisdictions around the world who have chosen to make workplace and public safety a primary concern when developing balanced workplace safety rules. Random alcohol and drug testing exists in Australia, Great Britain, India, and the United States as just a few examples. The U.S., as an example, has been mandating random alcohol and drug testing in transportation since 1995 under DOT regulations, and many Canadian organizations are already affected by these rules. Companies operating cross-border, such as railways and trucking companies, must follow these mandatory rules while operating in the U.S. Our questions are simple. What is the difference between a truck driver in Canada versus the U.S.? Are not the safety expectations and requirements the same? Third, a new legislative framework in Canada will provide certainty on workplace rules for all parties, including employees, unions, and employers. The same mandatory rules will apply in all workplaces in a uniform and fair manner. Policy will be set by the government, consistent with all other workplace safety rules in the federal sector, and costly, lengthy, and confusing legal proceedings will be avoided. Workplace safety in the federal sector is mandated under Part 2 of the Canada Labour Code and the associated regulations. While these documents contain thousands of provisions related to workplace safety, there is not a single reference in either to the rules related to the safety risk associated with alcohol and drug use in the workplace. The consequence of this, unfortunately, is that the rules get established by the courts. The leading case on this issue, Irving Pulp and Paper, was a split decision of the Supreme Court of Canada with a strong dissent by 3 justices, including the Chief Justice. There are also dozens of other arbitrations and court cases in this space, some being contemplated currently. The result? Employers are confused as to whether or not they can undertake alcohol and drug testing, and if so, in what situations. Clear direction is required from government. On this note, I think it's important to reflect on the words of the dissenting justices in the Irving Pulp and Paper case, and I quote, "The New Brunswick legislature has within the scope of its legislative authority the power to take drug and alcohol testing outside the purview of the collective bargaining process, as some other legislative bodies have done in certain contexts. Indeed, some experts have suggested there is an overwhelming argument in this country for legislative direction and definition that would add consistency, uniformity of meaning, and predictability for all workplace stakeholders. That decision, however, is one for the New Brunswick legislature and not for this court." End quote. Further, the ground is shifting in Canada. The Canadian Nuclear Safety Commission has just moved forward in November of 2017 with fitness for duty regulations that include alcohol and drug testing, including random testing. The Transportation Safety Board report, also from November of 2017, in the Carson Air crash, strongly endorsed the use of alcohol and drug testing, including random testing, for the aviation industry. There is a noticeable legislative gap in Canada that needs to be addressed. Finally, a quick note about privacy. Some groups will argue that alcohol and drug testing infringes an individual's privacy. We don't believe this is accurate. Employers know they have no authority over the choices made by employees during their off-work hours. However, employers expect employees to work safely and not to be under the influence of alcohol or drugs while at work. Workplace and public safety must take precedence over individual privacy rights. Bill C-46, the companion bill to Bill C-45, related to impaired driving, will allow random roadside alcohol testing, a provision that the government believes meets the charter test. If privacy rights are outweighed for an individual driving a single automobile on the highway, the same logic must apply to a pilot flying a plane with 200 passengers, a train conductor hauling 50 cars of chemicals, a bus driver carrying 60 passengers, a truck driver operating on a major highway, or any worker whose workplace actions could impact the life of a coworker or the public. For this reason, we believe a legislative solution is required. We ask that you amend Bill C-45 to accommodate these important concerns. Thank you.
Thank you very much. And finally,